Mole.
Hi, I'm David Smith and this is Valley Mole, the show that digs in and around Silicon Valley, searching for insights into technology news stories, the patent wars, and the business of startups. The question buzzing around Silicon Valley today is whether the injunctions that have been issued in courts overseas, barring the sale of the Samsung Galaxy Tab for infringement of patents held by Apple, could come to the US. Can the US federal courts bar products from being made available to US consumers? And the short answer is yes. In fact, it happens all the time. Not only by the federal court, but also by the ITC, where the products are blocked from being imported into the ports. The long answer requires us to look into the remedies adopted by US courts to settle patent infringement disputes. And there are basically 5 steps to winning a provisional or permanent injunction in the US to block the sale of a product based on patent infringement. Step 1 involves gathering compelling evidence of infringement. All the elements of a patent claim have to be identified or practiced in the product for infringement to be found. Step 2 requires convincing the court that the harm suffered by the patent holder, if the product is allowed to remain on the market, far outweighs the harm suffered by the product vendor if the injunction is issued. Step 3 involves convincing the court that money damages are insufficient to repair the damage caused by the patent holder to the patent holder by allowing the product to be sold on the market. A reasonable royalty payment is usually awarded by the court to compensate the patent holder for past infringement. And generally this is calculated as a license fee for each unit sold by the infringer. Now, there are multiple triple damages often awarded for willful infringement. So damages can be calculated at 3 times a reasonable royalty. But this must be insufficient to remedy the harm caused by infringement if the injunction is to issue. The patent holder must suffer some harm to its brand and image, or some harm above and beyond what can be compensated by paying a royalty. The court must be convinced that money damages will not suffice and an injunction has to be issued barring sale of the infringing product if a proper remedy is to be awarded by the court. Okay, so step 4 sees the court then investigate whether the injunction would be in the interests of the public. Courts do consider public interests when deciding on injunctions. Step 5 requires the patent holder to show it's a participant in the market, as injunctions are now denied to non-practicing entities. The patent holder now has to be marketing its own products in the marketplace to win an injunction in the US courts. Merely holding a patent is not sufficient today. So by following these 5 steps, injunctions are regularly issued by the US federal courts, barring the sale of products to US consumers. As they're a common feature of patent lawsuits, don't be surprised if injunctions are issued in the current smartphone and consumer electronics patent wars. However, the US economy is different from the other markets on account of its sheer size. As the US market is so important, companies and courts will do what they can to avoid restricting the choice available to US consumers. So injunctions are certainly possible in the US, but with public interests, a free market mentality, and billions of dollars at stake, it will take some convincing before the federal courts block the sale of hot products in the United States. We'd like to thank the sponsors of Valley Mole. Tynex, the full-service patent broker, operating the world's largest technology trading exchange. Silicon Valley Business School, the unique online resource for students and teachers of entrepreneurship, high-tech law and technology commercialization. And valuemypatent.com, the only place to go for rapid, realistic online patent appraisals.